Have you ever thought about what it would be like if you lost your job simply because you spoke up about being treated unfairly at work? Maybe this is something that's already happened to you. It happens more often than you think, and proving retaliation isn't as easy as it should be. Today, we're talking about how workplace retaliation claims are handled in court and what employees need to know when attempting to prove retaliation. And stick around until the end because I'm going to share 5 signs you can use to know if a potential employer is toxic or retaliatory before you start working there. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. On this channel, I talk about real legal cases that demonstrate how the law might apply to you, to your circumstances. And today's case is going to demonstrate the standard that courts require employees to show in order to prove that retaliation has occurred. Let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult a qualified attorney or HR professional for specific guidance tailored to your needs. And don't forget to like and subscribe. This story starts with Dr. Nail Nassar, a Muslim physician of Egyptian descent, and he worked at the University of Texas Southwestern. His primary duty was to provide care to HIV and AIDS patients, and he complained to human resources, and this is where the story really started. He made a complaint to human resources that his supervisor, Dr. Beth Levine, created a hostile work environment by several things that she did to him and said about people of Egyptian descent. He said that she constantly made derogatory comments and offensive remarks about Middle Easterners. And she also said that Middle Easterners were lazy. She openly expressed contempt and disapproval for hiring people of Middle Eastern descent. Dr. Nassar also said that Dr. Levine compared him to his colleagues all of the time. She was overly critical of his productivity, his billing practices, and she didn't consider the constraints that he had on his position that limited his abilities in these areas. She also discouraged Dr. Nassar's promotion. She lied and said that another doctor was opposing Dr. Nassar's promotion, but when in fact it was Dr. Levine. And so Dr. Nassar later found out that Dr. Levine was doing these things and he was just overwhelmed. He said that it made him feel as though his work environment was too stressful, increasingly hostile, and ultimately he decided to resign from his position. But his resignation was just the beginning because after he resigned, Dr. Nassar filed a complaint with the EEOC alleging discriminatory and harassment at UT Southwestern that resulted in his forced resignation, and that his resignation followed his complaint to human resources, his complaint that he made of harassment and discrimination, and that his resignation was actually the result of retaliation he suffered that followed the allegations he made against UT Southwestern. He also said that the University of Texas blocked his attempt to gain employment at a different hospital, and that was also the direct cause of his complaint. In addition, he named two more doctors who worked there with Dr. Levine. He said that they were also a party to the harassment that he suffered. And so he named them in the lawsuit for discrimination and retaliation as well. And on May 24th, 2010, the jury returned a verdict in favor of Dr. Nassar. They said that UT Southwestern constructively discharged Dr. Nassar and discriminated against him on the basis of his race and religious preference. And they also said that he was retaliated against because they blocked his employment opportunities and they awarded him $438,000 in back pay and $3 million in compensatory damages. So, I want to take a moment to clarify what constructive discharge means and how it applies to employment law issues, because this is a very important experience that a lot of people have. We all know what a resignation is, and that happens when an employee voluntarily decides of their own free will that it's time for them to start a new chapter in their life. So, they leave their employer. But a constructive discharge, now, something like that is yes, I'm resigning, but no, I'm really not, because it occurs when an employee decides that it's time for them to leave because the working conditions are just so bad that anyone, any reasonable person in the same situation would feel compelled to quit. And in those types of cases, even though the employee technically resigned, the resignation is legally treated as an involuntary termination because the employer created an environment that was so hostile that it was unbearable and the employee could not continue to work in that environment. And so this is what happened with Dr. Nassar. And I wanted to point this out because many people mistakenly believe that if they do resign, they lose the right to pursue a claim for harassment or unfair treatment that they've experienced. But the truth is, even if you resign because of the working conditions, you can still pursue a claim against your employer. And remember that taking care of yourself is just as important as pursuing that claim. And sometimes it's better to walk away even before securing a new job so that you can pursue justice from a place of stability, away from that toxic, hostile environment that is impacting your health and your well being. So here is a plot twist. This case actually went all the way to the Supreme Court and they ruled against Dr. Nassar. They basically said that in order for retaliation to be legitimate, it must be decisive and directly the reason for an employer's actions. So basically, they don't want a claim to come to court because an employer has made a legitimate business decision and now that decision has had a negative impact on people, because sometimes people are going to experience things in the workplace that are not related to retaliation, but there could have been a complaint that they made about their employer to human resources. And now there's this work that's going on, that decisions that are being made in the workplace by leadership, by management, by an organization, and those decisions are going to have a negative impact on a person, even if that person is filed a complaint or they have not filed a complaint. The courts want employers to be able to make decisions that they need to that are in the best interest of their organization. So the issue now for courts is to determine whether an employer's actions are retaliatory or if they are just related to a business decision. And of course, this has had a significant impact on workplace retaliation claims because it's raised the burden of proof for employees when they allege that their employers have retaliated against them for discrimination or harassment. If you want to know more about subtle signs of retaliation, watch my video Covert Retaliation Explained. In that video, I talk about a case where the Supreme Court said that retaliation includes any action that would discourage a reasonable person from speaking up, not just terminations. And this ruling was actually a big win for employees because it expanded retaliation so that it included more than just a termination of employment. So check it out. So, what does all of this mean for employees who have experienced retaliation and are now considering pursuing a claim? Where there are four facts that would support your claim and help you prove that you've experienced retaliation. The first one is if the negative action that you experienced happened close to a time when you filed a complaint. So, whatever that act is that you experienced by your employer that had a negative impact on you, how close is it in time to when you made a complaint about your employer, either your supervisor or you complained to human resources? If that time is narrow, then that would certainly support your claim. The second fact is if your employer has a lack of justification for what they've done to you, if their justification is weak or inconsistent with what you have seen other employees experience, that would also support your claim. The third thing is if there is a pattern of behavior, if the employer has retaliated against others before, because ongoing discrimination means that there's a problem within an organization and there is no intention to correct it. And then the last one, the fourth one, of course, is direct evidence. Any email, text, conversations that hint at retaliation would certainly help support a claim. There are 5 signs I have personally used to know if a company is toxic or retaliatory to help me decide if I want to work there. And listen, sometimes you need a job. I get it. You don't care if the environment is toxic, you just need the income. I know these tips aren't always the determining factor, but when you join, at least you will have your eyes open with insight about the work environment, and that can also be very helpful. Number 5 is a lack of transparency. And this is anytime a company discourages employees from discussing pay, or they have policies that actually ban discussions about pay or discourage employees from reporting misconduct. Those types of things are a red flag and might hint at a toxic environment or one that is retaliatory in nature. Number 4 is actually pretty common, and this is a revolving door. High turnover is a big red flag. It suggests that a company has poor leadership, it's burning people out, that people are possibly retaliating against, but they're not saying anything. They just go ahead and leave the organization. So if you have a company with low uh, tenure of its employees, that is also an issue, and I would consider it a red flag. Number 3 is vague or evasive answers during the interview. If leadership avoids questions that you're asking, for example, about work life balance or management style or employees' concerns and how they are addressed, they might be hiding something. And so that is also a red flag that the environment could be toxic or retaliatory. Number 2 is employee reviews or retaliation complaints online. If you find multiple reviews that mention fear of speaking up, sudden terminations, or HR siding with bad managers, retaliation is likely prevalent in that environment. One is researching the CEO's public statements, his social media posts, and interviews. If they promote intimidation rather than growth, you need to pay attention to that because leadership sets the tone for the culture in the company. And if a CEO promotes fear, like what I saw, did a case on Jack Welch's rank and yank system he had when he was CEO of GE. If you want to take a look at that video, his statements were very, very open about how he operated in a fear based culture and he wanted to weed out those who were considered to be weak and a very high pressured work place. Those types of CEOs, comments that are made by CEOs, are certainly an indication that that environment is toxic and unhealthy. Retaliation happens, and it happens in workplaces every day. And this case made it harder to prove. So that's why knowing your rights is so important. Have you ever witnessed workplace retaliation? Let's talk about it in the comments. And if you found this video helpful, be sure to like, subscribe, and hit the notification bell